Okay, it's 4 o'clock, so we shall begin. Good afternoon, everybody, and welcome to this Parker Bullen webinar today on the topic of watertight wills. I hope you are all well. Thank you very much for coming along, taking time out of your busy day to join us. It's great to see so many of you attending this afternoon. My name is Ketan Patel, and I'm going to be the host for this short webinar. Essentially, that just means that my job is just to push all the right buttons, ask any questions that come forward, and just generally keep things on track. So this is an informal chatty style webinar, so please do get involved. Please use the questions button. You should all have a Q&A option on your Zoom screen. If you'd like to ask any questions, that will just enable you to type a question in and send that through, and I can then pose that to our two presenters this afternoon. We'll try and cover as many as possible during the webinar, but if not, it'll be at the end of it or in the future. So before I hand over to today's presenters, just a couple of housekeeping matters. So we intend for this to be a 20-minute webinar, although with my short intro here now and any questions that we have, we may run over into 30 minutes. We are recording this webinar and a link will be shared with you afterwards, so you can watch it back again in the future. And you'll also receive after this webinar a summary handout of all of the points covered, so you can reflect back on it and then get in touch if you have any questions. So really the purpose of this webinar is just for us to share with you some useful information, some practical tips and some guidance on the topic of wills. And any advice that we give is purely generic. It shouldn't really be relied upon unless you've spoken to us separately and we've provided you with advice that's pertinent to your individual circumstances. So in today's webinar, as I've said, we'll be talking about the execution and the validity of a will. And to present the topic, I would now like to hand over to today's presenters. We've got Bethan Creasy, who is a solicitor in our Wills as Probate and Estates team, and Andrew Marshall, who is a paralegal in the same team. So over to you, Bethan and Andrew.
Thank you very much indeed, Ketan, and welcome to everyone who is in attendance today. The impact of COVID-19 has been experienced across all sectors of UK industry, and the legal sector has been no exception. We've had property transactions that have been stalled, we've had clients waiting on correspondences back from HMRC, OPG, probate, all of the different government institutions. And for some departments, business has totally stood still in the first few months of lockdown. But one particular area that has seen considered working is in the area of wills, which is to be understood. People, with all the uncertainty going on in the world, people want the certainty of knowing that whatever happens, the people that they can trust can be left to administer their estate and make sure all of their assets and personal property go to the people who they want to go to. With this increase in business has seen an increase in inquiries from people asking us just how exactly can they sign their wills. Suddenly we've had to deal with the added complications of lockdowns, bubbling, social distancing. Suddenly the simple act of getting 2 or more people in a room at the same time, that has all just suddenly gone out of the window, and they come asking to us, well, how are we going to go about doing this? So the question I'd like to present to you all today is this: wouldn't it be comforting to know that your will has been executed correctly, even during a time when we all need to be socially distant? Now, if you or anybody else thinks that that's something that they could do with knowing about, then I think that we'll be able to help you with that today. So what I'm going to do is I'm going to set out a brief outline of the law as it currently stands, and from that infer the best procedure on how to properly sign and have your will validly witnessed. And I'm going to pass over to my colleague Bethan, who's going to comment on the recent changes that the government has brought in, allowing the use of remote video witnessing, and whether or not that actually helps in any kind of practical level, and just what the best alternatives are for now. So we'll take a look at the current law as it stands at the moment, and I'll take each one in turn. So firstly, no will is valid unless it's in writing and signed by the person making the will. There's no restrictions on what you can use or what it is written on. The courts have interpreted quite a reasonably broad outline for that. Having said that, just because you can write your will on the back of a cigarette packet, no, that's not something that we can advise, and you're probably best off not doing that. Okay, the second one, the person making the will signs it, intending it to be their will. Again, courts have been pretty reasonable in broadly interpreting that. People's signature, we've had cases where a rubber stamp has been interpreted as signature, people just printing their name. If the person making the will intends what they put to be their signature, it will be interpreted as their signature. Thirdly, two or more witnesses see the person making the will sign it. Now, the witnesses don't need to know the contents of the will. They don't even really need to know that the document they're seeing is a will. All they just need to know is the person making that document has signed their name and they've seen them do it. And lastly, the witnesses sign their will in the presence of the person making the will. Now, we have had some inquiries about what actually does constitute a witness for the terms of signing a will. And generally, the rule of thumb is that the only person who you really don't want witnessing your will are any recipients to any gifts that you make, or the spouse or civil partner of anyone making that gift. It's not going to invalidate the will, but it is going to invalidate the gift that those witnesses get. And if it comes to the point where the probate registry has to start striking out gifts from wills, we could, in the worst case scenario, start looking at partial intestacies or even worse, entire intestacies, which you don't really want if you're going to all the trouble of making a will. So from those 4 points, we can call together the best practice for signing and witnessing a will. Again, I'll take all that in turn. Firstly, get the person signing the will, the testator, and two suitable witnesses. They remain together in the same room, ideally, and attentive throughout the process. Secondly, the two witnesses both watch the testator, date, and sign the will. And lastly, each witness in turn then signs the will, watched by the testator and each other. Three-step process, bish, bash, bosh. If you do that, jobs are good, and that will is most likely to be held as valid. Now, one of the main important things to pull from that is the requirement for presence. So line of sight is crucial. I've got a couple of cases here just from centuries past just to demonstrate that. Firstly, the case of Brown v. Skerrow from 1902. The testator put together a will in the middle of a busy shop and asked for a couple of his staff to sign it. Now, that second witness didn't actually see the testator putting his signature on the will, and he just took his word that he signed it and just signed his name as a witness. And the courts held that will to be invalid because he hadn't seen it. And we contrast that with the 1781 case of Castle v. Dade. That will took place in the middle of a horse-drawn cart carriage, as it were, and the witness took it outside to sign this will and was almost entirely obscured by the horse in front of it. But for a brief second of that horse rearing up, that was enough to constitute line of sight and for all the signatures to have been witnessed. So two different cases just demonstrating how you have to be attentive, you need to have presence throughout. So that brings us ultimately to the quandary. If you need to have people in the same room at the same time, then how exactly is that going to work in the middle of lockdown? How are you going to get two people together at the same time to see the signature being witnessed or to see it being signed in the first place? And does the newest government regulation that has been brought in, does that actually make any kind of an impact? Does it work in practice? So what I'm going to do, I'm going to pass over now to my colleague, Bethan Creasy, who is going to go into details on that very thing and, if all goes to plan, answer that question. Bethan?
Thank you, Andrew. So to follow on from Andrew's excellent points so far, the coronavirus outbreak has meant that putting the law into practice has been rather tricky. So due to the government guidance with social distancing and lockdown in the spring months, we found that our clients haven't really been in a position to get multiple people in the same room at the same time. And this has been a particular barrier for vulnerable people having to shield because they've been isolated since the 1st of August. So the UK government has announced plans to change the law or alter it slightly to allow the wills to be witnessed virtually via video technology. So for example, Zoom, FaceTime or Skype. So the new laws will come into effect from next week, the 28th of September, and it will apply to all wills backdated to the first recorded case of coronavirus in Britain on the 31st of January 2020. And the legislation of virtually witnessing wills will remain in place until the 31st of January 2022, or as long as is deemed necessary. So witnesses can be virtually present via a video technology such as Zoom or FaceTime to witness an individual signing their will. And once the will is signed, it is then posted to the witnesses who sign it themselves during live video conferences. However, government advice is that the legislation of virtually witnessing wills, whilst it's useful in the current climate, we suggest should be used as a last resort. However, if it is your last resort, then we will go on to the next slide and we will show you how to do it correctly. So if it is to be used, so if virtual witnessing is to be used, then we suggest that you take the following steps. So the testator, so that's the person who's signing the will, and their two independent witnesses confirm sight of each other over video link, and they give their full names. And I must say here that you must video record everything that you do so that we can use it as evidence later down the line if the validity of the will is challenged for whatever reason. So the testator confirms sight of each other with the witnesses, and everyone gives their full names. And the testator, so again, the person signing it, shows them the cover of the will and the signing page, and then they sign. So the person signing must be in full view of the camera, and you can't just see the face, you've got to be able to see the person signing the will and everything that needs showing. The witnesses will need to confirm that they can see, hear, and they acknowledge and understand their role in witnessing the signing of the will. And then once all that's done, the testator will send the will to the witness, and the process is repeated until both of the witnesses have signed it. And the will is then returned to the testator, and that's it done. However, you can see that there are quite a few pitfalls in doing it this way, and the legislation doesn't provide for a will to be signed in counterpart, and nor can it be signed electronically. Therefore, the same copy of the will must be signed by the testator and two witnesses. So as a result, the will must be transported, whether it be by hand or by post, to each witness, and a further video call or two calls if the witnesses aren't in the same location will then be required. And both the witnesses and the testator have to be present on all calls. So you can see that this can cause significant problems if one of the three people can't join the video call. For example, they go on holiday or they don't feel very well. Or worst case scenario, one of the witnesses dies in the process. In the event that the testator, for example, were to die before the will has been fully signed, then the will isn't valid. So you can see that there are various reasons why we suggest this being the last resort. And we advise caution in moving forward because there are risks in having the will witnessed virtually. So the risks that are immediately apparent include the prospect of the video call freezing or the video dropping, internet connection being lost, which is an irregular occurrence. This could then result in a will not being valid. And in any event, as we've said, the government guidance as to the process of witnessing a will virtually should be followed to reduce the risk of the validity of the will being challenged at a later date. So in terms of best practical options, ideally, we would like to meet with you to assist with you witnessing your wills. However, if this is not an option, as it has been for many of our clients, the best practical options are witnessing through the window or the open door of a house or vehicle, witnessing from the corridor or an adjacent room into the room with an open door, or witnessing outdoors from a short distance, for example, in the garden. So our clients have found the last option during the summer, witnessing in the garden, has been, ideal, but obviously with the changes in weather, people are being forced indoors. So we're satisfied that witnessing through a window or through an open door, for example, satisfies Section 9 of the Wills Act, which, is what Andrew went through at the beginning of the webinar. So if you come into the office, for example, we sit at one end of the boardroom and you will sit at the other, and we're literally sliding papers down the table. So wills can be witnessed whilst adhering to social distancing. So, there are a lot of options out there, but as we've said, the main takeaway is virtually witnessing wills is possible, but please use it as your last resort. So, as Andrew explained, so long as the witnesses have a clear line of sight of you signing the will, then they can act as the witness. So that covers everything in terms of the content of our webinar. I don't know if anyone has any questions out there or wants any clarifying on any of the points that we raised.
Yes, thank you, Bethan and Andrew. As Bethan just said, if anyone has any questions, please do send them through now, and we'll pose them to Andrew and Bethan and them to answer. I have got one question here for you, Bethan and Andrew, which has just come through. This is from Sandra, who asks, what should I do if I suspect my will has not been validly witnessed?
So in that situation, we would advise, that you come in and speak to us and we can discuss it. But just to speak generally, the best advice is to execute a will or amend a will in the best way possible without a risk to your health. So if this means that you have to write a new will or codicil and it's executed in less than ideal circumstances, and the requirements of Section 9 are being stretched, in other words, we're not sure if it's being witnessed properly, then the best practice is to prepare a short statement from the witness to accompany the signing so that the circumstances are outlined, and this will then help to protect the validity in any event of a challenge of the will after death. So essentially, if there's any if you think there's any risk involved, then we recommend you coming in and witnessing it with us. But in any event, if the will's already been witnessed, then please do bring it in anyway, and we can go through, your next steps. Okay.
Excellent, thank you there, Bethan. I have got another question here for you both, and this comes from Mark, who asks, does it matter if the testator or any of the witnesses are situated abroad?
Thank you, Mark, for that question. That is actually a good question. We haven't come across that in the government guidance, that they have specifically had to be in the same country. I think just practically speaking, though, in sending the will abroad for the witness to then sign it and then return it, there's many risks involved in that. So whilst we don't think it's impossible, practically speaking, we wouldn't suggest it. Have you got anything to add, Andrew?
No, there's definitely practical implications of that, because that will is not in effect until the testator and both of those witnesses have signed. So certainly with post being what it is at the moment, we could have a whole month where that will is essentially in ether, not having been properly executed. So I think if you can have witnesses a little bit closer to home, I think that would be the way to go about things.
Yeah, I agree. Yeah.
Excellent. Thank you very much, both. And just one final question that's come through, and this is from Jane, who asks, who can witness a will, and what do you mean by an independent witness?
essentially, as I reiterated, the main hard and fast rule for people witnessing a will is that it can't be a recipient of any of the gifts made in the will, and it can't be the spouse or the significant other doing it. As I said, it won't null and void the will, but we get down a path of those gifts essentially having to be struck out. So it's not something that is definitely to be recommended.
Yeah, so we always suggest, just to be on the safe side, don't get a member of the family to witness it. Ask the neighbour or a colleague, someone who has no, personal interest in your estate or your will at all. Okay.
Excellent. Well, thank you very much both for that. That was a very informative and interesting presentation. I'm sure everyone who's here will agree. So if anybody does have any further questions, then oh, here we go. Sorry, we have got just a question that's just come in. So this question asks, for a virtually witnessed will, if the testator passed away before it was signed by the two witnesses post the testator's virtual signing, would it be invalid?
So is the question there, if the witnesses haven't signed it, but only the testator?
I believe so, yes. Yes, I think so. I think that's what the question's asking.
I can't see that will would be considered to be valid then, no.
So for a will to be valid, it has to be signed and executed, in accordance with statute, and that includes it being witnessed by two independent witnesses. So if the testator died whilst, the will was in transit, then unfortunately the will would not be valid.
Excellent, thank you. I haven't got a name for who submitted that question, but if you would like a proper answer on that, if we didn't quite get what you were asking there, then please do get in touch. And I'm sure Bethan or Andrew or one of the team will be happy to answer that in a little bit more detail. So yes, if you do have any further questions, as I say, do get in touch with us. Thank you to Bethan and Andrew for a very good presentation there. Just a reminder to everyone that you will receive a recording of this webinar, as well as a summary handout of everything that was discussed in this webinar, and you can get in touch if you have any further queries, as I say. Thank you very much for attending this afternoon, and I hope everyone enjoys the rest of their day. Thank you.
Thank you. Bye-bye.
Thank you very much.